Okay, so I've finally finished collating absolutely everything I can find regarding the ARCCA guys, including the cited June 10th hearing testimony, referred to by Mr. Breenan. And I've also referenced some case law to see what Auntie Bev's rulings are based on. Because, you know, her famous saying, in Massachusetts, we don't do that. But if there's case law in Massachusetts, or that can be used in Massachusetts, then she's just adding to the big pile of issues that we've already discussed previously that could be added to the habeas petition. So let's start with the earliest mention that I can find, excluding what I have previously covered, of course, leading up to all of this. Beginning with Auntie Bev harassing the defence because they can't obtain the exact information that the Commonwealth wants from the ARCCA witnesses.
So let's try and work everything out. The rules are very clear, and you need to provide this information.
And I thought we had, but I'm happy to have that additional conversation. And I'll do the same thing with regard to the ARCCA witnesses as well.
So is there anything specifically, Mr. Lally, that you're looking for today in response to the biomechanical engineers?
Just specifically what their opinions are and what they're based on.
And who did what?
Who did what.
Should be fairly easy to provide, Mr. Jackson.
It has been in about a 9 or 10 page report. It's detailed, single-spaced.
But does it say who did what? I read the report as part of the federal materials. I couldn't figure out who did what. So.
Okay, I'm happy to talk to Mr. Lally about that. I believe the answer is going to be, in sum and substance, all of them work together as a team to come to the opinions and conclusions that are recited in the report. But I'll be happy to have an additional conversation with Mr. Lally about that. I don't know that I know every single thing. As a matter of fact, I don't know every single thing that everybody did, who screwed what bolt into what nut, etc. But I think by and large, Mr. Lally and I can come to an agreement about what the contours of each of their testimony would be.
Okay.
And by the way, they are accident reconstructionists, so there's a...
Do you have their CVs?
I do, and so does Mr. Lally.
I do.
Anything on the CV about being accident reconstructionist?
There is listings of accident reconstructionists, but I think that's part of the Commonwealth's request for a voir dire is the qualifications. I don't think meet that standard for them to be able to testify in that area.
All right, so two things. When the two of you were working on this between now and Monday, if the Commonwealth is not satisfied in requesting a voir dire, I need to hear from the two of you whether we need to do that before the evidence really gets started, or if it can be done before the witness testifies.
Okay.
All right.
Notably, the Commonwealth is raising Daubert-Lanigan issues here. This will become laughably ridiculous during the trial when we hear the Commonwealth's expert, who is a so-called accident reconstructionist, versus the head of the Department of Accident Reconstruction at ARCCA. And then later on we'll also see that Judge Bev's concerns about who did what is amply addressed during the voir dire that she awarded the Commonwealth as a sanction against the defence for the crime of being unable to compel the FBI to meet their Rule 14 obligations. This issue will compound as we go on.
I will be arguing.
All right, so...
Given to us December 4th. You only filed yesterday.
Right.
So what I can say, Mr. Yannetti, is that it appears that you served counsel for the Commonwealth with this motion, but you did not serve the U.S. Attorney's Office. So the U.S. Attorney's Office has a right to be heard on this order, on this proposal that you have. So I need them here. I need them served. So you can serve them and we'll get a date.
Oh really, Auntie Bev? The FBI witnesses were not compelled by a subpoena to testify. So what grounds does Auntie Bev have to demand such a thing? We already know that under Brady v. Maryland, the FBI had an independent duty to disclose exculpatory evidence. Because the FBI, not the defence, initiated the disclosure of these witnesses, the defence did not need to seek approval from the USAO. In Kyles v. Whitley of 1995, the Supreme Court reaffirmed that government agencies, such as the FBI, have an obligation to disclose exculpatory evidence to ensure a fair trial. If the FBI had already determined that withholding this evidence would violate due process, the judge had no valid reason to impose additional procedural burdens on the defence. Suggesting that the USA's involvement was necessary flies in the face of reality because the FBI already decided to make these witnesses available. The defence did not compel them. There's no legal or procedural rule that requires a defendant to serve the USAO when an agency voluntarily provides witnesses, unless the defence is seeking to compel testimony via subpoena, which they weren't. Judge Bev essentially created an unnecessary burden on the defence, which suggests an intentional tactic to hinder the defence. Under Wardius v. Oregon, 1973, the Supreme Court ruled that discovery rules must apply equally to both the prosecution and the defence. The judge's demand was procedurally unnecessary and created an unfair burden on the defence. This is yet another example of unnecessary procedural barrier placed on the defence and could be included in the federal habeas petition as evidence that the trial judge imposed unnecessary procedural burdens to hinder the defence's ability to present exculpatory evidence. In Ake v. Oklahoma of 1985, the Supreme Court ruled that a defendant must have equal access to expert testimony and investigative resources. So if the judge created unnecessary procedural hurdles to delay or obstruct defence witnesses, this violates due process. It also strengthens the habeas petition by showing that the ruling reflects a pattern of judicial bias in favour of the prosecution, which deprived the defendant of a fair trial. The federal court could examine whether these rulings were intended to undermine the defence's ability to present exculpatory evidence. But wait. There's more.
All right, 27. I'll hear you, Mr. Lally.
Yes, so, Your Honor, this motion eliminates in reference to prohibiting reference to any federal investigations conducted by the U.S. Attorney's Office or the Federal Bureau of Investigations. So to this point, the U.S. Attorney's Office has publicly confirmed that at no time has the U.S. Attorney's Office named any person or entity as a target. So any sort of reference to, and essentially what they've stated throughout the course of, and I know the court has had a chance to review those materials, but what they state is essentially their investigation into some unnamed criminal activity or some unnamed crime or there's nothing specific to any specific person or entity that is contained within those materials. So what the Commonwealth is submitting is that any reference to the fact that those things occurred is therefore unfair, essentially biases against one side or the other based on that, and it really has no relevancy. As far as making reference to, if counsel at some point, either side, wants to make reference to testimony or statements, reports, things of that nature that were provided in the course of that discovery pursuant to the TUI, obviously that's perfectly permissible, but it also can be done without making reference to where that item came from. As far as you testified previously in relation to some investigation on such and such a date, you spoke to a law enforcement agent on such and such a date and you said this. So if it's needed for those kinds of reasons, as far as impeachment and whatever, that's obviously perfectly permissible, but any reference to that in front of the jury, Your Honor, is something that the Commonwealth would submit is simply impermissible and irrelevant to the facts as they pertain to this case. So for those reasons, the Commonwealth would ask that this motion be allowed.
Is there an objection to this?
There is. Your Honor, the Commonwealth's position can be basically summed up in their moving papers with the following sentence that they drafted. The proceeding would be unfairly prejudiced if the defendant is permitted to rely on the mere appearance or existence of a federal investigation, especially where the investigation was shaped and influenced by the defense. First of all, the defense does not and did not shape or influence any federal investigation. The federal government is more than capable, Your Honor, and I think the Commonwealth knows this, of making its own decisions and about its own investigations. Second, and just as importantly, the Commonwealth cites no authority whatsoever that stands for the proposition that the mere mention of a federal investigation prejudices state court proceedings in any way, shape, form, or fashion, and that's because there is no authority. That authority does not exist. But most importantly, and this is critical, it is going to be critical to give the trier of fact, this jury, the proper context in which every one of the statements or every bit of the evidence is presented and how it came to light. It's essential for the jury.
How are you going to do that? How do you propose it? Is somebody from the U.S. Attorney's Office on your witness list to come in and talk about it?
There are federal agents. No. We don't anticipate presenting the fact that there's a federal investigation.
Isn't that what this does, if you mention it?
No. What this does,
explain to me why that's not so.
That's what I'm doing.
Not yet, you haven't, so please explain that.
As the court knows, it's essential that the jury is given the context in which every single statement, whatever the statement might be, is brought to light.
Does that mean, do we say, in the prior trial that resulted in a mistrial, you said this?
No, but you would say, when you were speaking with Officer Smith or Officer Jones from the Canton Police Department at the Canton Police Station in this particular context, did you say this? When you were questioned by the Commonwealth's attorney in this proceeding, did you say this? When you were questioned by the United States attorney in this hearing, did you say that? That's what we do. Otherwise, it's perpetrating a fraud on the jury. The information that's gleaned during the federal investigation was revealed, Your Honor, importantly, by a neutral third party. A neutral body that's not connected in any way to this case. The Commonwealth has a stake in this case, very obviously. The defense certainly has a stake in this case, but the federal authorities have no stake in the case of the Commonwealth versus Karen Reed. Thus, the evidence procured by that neutral agency, which is independent of the case, is subject to a different and completely different level of scrutiny, a completely different level of assessment by the jurors. That is an important fact. There is no other way to truthfully and honestly present this evidence to the jury. Think about some of the questions that the court just posed. What were the circumstances in which you changed your testimony, sir? He's going to say, well, I changed my testimony, potentially, when I was called before a federal grand jury and I was asked questions under penalty of perjury. Why did you finally admit certain things when you were confronted with additional evidence, ma'am, and where did that evidence come from? Well, I was called before a grand jury and I was asked, or I was interviewed by a federal agent and I was asked or confronted with additional information, text messages, phone calls, etc. Or the third example, where did that additional evidence come from, officer? Text messages, phone calls, private communications. Oh, it came from a hearing in which I was questioned by a United States attorney under penalty of perjury in front of a grand jury. The jury's entitled to those answers in that context. If we were to do what Mr. Lally suggests, if we were to take that invitation, oh, well, you were asked by a prosecutor at a former hearing XYZ. That would leave the jurors with the imprimatur of the idea that the Commonwealth elicited those questions, that the Commonwealth did their job, when we know, in fact, it didn't. The answers to those questions directly go to Ms. Reed's Bowdoin defense. Bowdoin talks about the inadequacy of an investigation. Obviously, Mr. Yannetti can talk more about that in just a second. We have information that a different agency was able to uncover information that the state investigation ignored. That's important. And it's important for the jurors to be able to weigh and balance that information and how the information came to light. If the truth is actually hidden from the jury, which is what the Commonwealth is asking the court to do, that the evidence was produced was the product of a third party, the truth being that the evidence was the product of a third party inquiry unconnected to the state court case, then that jury is left with a false impression, false information, and it'll be unable to properly assess the true facts, which is what we're trying to get to, the true facts. Why is the Commonwealth so intent on hiding the truth from this jury? I'll submit.
Okay. I'll likely rule on that today. So,
does Auntie Bev have standing to prevent the defence from mentioning that there's an investigation by the FBI? So in Massachusetts, the admissibility of evidence regarding ongoing federal investigations during a criminal trial hinges on its relevance and potential prejudicial impact. So of course, the state's claiming that it's prejudicial to them. But is that really the case? In Graham versus District Attorney for the Hampton District, the plaintiffs alleged that the District Attorney's Office failed to disclose evidence of misconduct within the Springfield Police Department, which was under federal investigation. The Massachusetts Supreme Judicial Court emphasised the prosecution's duty to disclose exculpatory evidence, especially when it pertains to the credibility of law enforcement officers involved in the actual case. But what we do know is that the federal investigation in this case wasn't just about general misconduct by investigators involved in the case. It was about specific misconduct related to this specific case. And that significantly strengthens the argument that excluding evidence of the investigation would be more prejudicial to the defendant than to the state. And there are key legal principles supporting the defendant's right to mention the federal investigation. Massachusetts courts have held that evidence challenging the integrity of the investigation is central to the defendant's right to a fair trial. This principle is rooted in Commonwealth v. Bowden, and you might be familiar with that because the defence did put a Bowden motion in. In Commonwealth v. Bowden, 1980, it allows defendants to question the thoroughness and fairness of a police investigation. Also under Massachusetts Rule of Evidence 403, relevant evidence should only be excluded if its probative value is substantially outweighed by the danger of unfair prejudice. That's what the states claim, that it's unfair prejudice to them. However, when the federal investigation pertains to specific misconduct in the case, the probative value is exceptionally high because it directly affects the credibility of key evidence or witnesses. Any potential prejudice to the state, by implying wrongdoing, is secondary to the defendant's constitutional right to expose flaws in the prosecution's case. Excluding evidence of specific federal investigations can violate the defendant's Sixth Amendment right to confront witnesses. As established in Davis v. Alaska, 1974, if a key witness is under federal investigation for misconduct in the same case, the defence has a right to cross-examine them about it. It's imperative to challenging the credibility of state witnesses. Moreover, under Brady v. Maryland, 1963, the state has a duty to disclose exculpatory evidence, including information from a federal investigation that could undermine the prosecution's case. The state's attempt to prevent the defence from mentioning the federal investigation raises serious due process concerns. It suggests a potential cover-up of misconduct, and it denies the defendant the opportunity to present critical evidence that could lead to reasonable doubt. Some applicable case law precedents. Commonwealth v. Tucchieri, 1992. The court held that suppression of evidence regarding specific misconduct violated due process and warranted a new trial. Commonwealth v. Washington, 2010. The court ruled that excluding such evidence created a risk of unfair trial because it deprived the jury of important context about the integrity of the investigation. In summary, in cases where federal investigation pertains directly to misconduct in the same case, the balance tilts heavily in favour of the defendant. The state's claim of prejudice is minimal compared to the potential harm to the defendant's right to a fair trial. The defence's need to present evidence of specific misconduct outweighs the concerns of the jury being influenced against the state. In addition, Massachusetts law does not support concealing the FBI's role. Massachusetts courts generally allow parties to introduce the source of expert testimony unless it creates unfair prejudice, which obviously the Commonwealth's claiming. Commonwealth versus Voir, 1997. The court ruled that expert witness affiliations can be disclosed as long as they are relevant to the credibility. Commonwealth versus Lano, 1987. The court allowed the disclosure of an expert's employer because it helped the jury evaluate bias and credibility. So when we're talking about one thing outweighing another, that's where we're talking about the weight of the evidence. And the fact that it violates the Sixth Amendment ties it back into the habeas petition.
Thank you, Your Honor. So, again, similar to the motion previous to it, the Commonwealth is not seeking to hide anything from the jury. What the Commonwealth is simply seeking to do is ensure that whatever information that's provided to the jury is actual admissible and relevant information and not the product of rank speculation. So this motion is seeking to prohibit reference to any pending internal affairs investigation or unfounded allegations of misconduct. And really, primarily what we're talking about here is any sort of internal affairs investigation related to Trooper Proctor and the 20-something-year-old civil case which resulted in no findings of liability that was referenced by counsel in their motion to dismiss with reference to Sergeant Lank of the Canton Police Department. Under the case law, including McFarland and Graham, the most recent case law, what they essentially attribute is that those types of information, when there is no finding of liability, there is no sustained finding of misconduct, there is no findings of liability by the party at question, that is simply not admissible. And so for those reasons, the Commonwealth.
Note, he references parts of the same case law that we just went through. But the problem with his argument is the internal affairs investigation has resulted in Proctor's job being on the line, and Sergeant Lank was found liable, or rather the city was. Nonetheless, the case law supports the defendant, not the state.
Commonwealth is just seeking that the defendant produce what the Commonwealth is entitled to under Rule 14 and what every criminal defendant in the Commonwealth of Massachusetts must produce to the prosecution. It was not until the day prior to trial on April 15, 2024, that the defendant provided notice of all their experts. During jury empanelment, the Commonwealth filed a renewed motion for reciprocal discovery, and the defendant was ordered within a week to produce the expert opinion testimony that the Commonwealth is entitled to. We are now entering, I believe, week 8 of the trial. The Commonwealth has not received any intended expert opinions, anything that those experts, any written reports, opinions, or anything that those experts have based their opinions on. Essentially, the defendant's strategic decisions not to retain their own expert, but rather rely on the U.S. Attorney's Office investigation does not alleviate them or relieve them from their Rule 14 obligations. As it pertains to Dr. Marie Russell, the Commonwealth did not receive notice that she's an intended expert until about week 6 of the trial on May 21st, and it wasn't until May 30th that the defendant provided a brief synopsis of what her expected testimony would be. Essentially, and looking at the balancing tests set forth by the case law, the Commonwealth was extremely surprised by this disclosure, and further, the Commonwealth would put that the defendant's delayed decisions to produce reciprocal discovery is in bad faith. It is intended to ambush the Commonwealth and conduct a trial by surprise. We are still receiving reciprocal discovery. Over the weekend, we received additional photographs that the defendant intends to use. The Commonwealth is extremely prejudiced by these delayed disclosures. So looking at all the balancing factors, exclusion of Dr. Russell is really the only remedy that's appropriate given that we are in week 8 of the trial. The Commonwealth cannot seek a continuance. The Commonwealth has their hands tied with how to effectively prepare for cross-examination of that witness as well as all the other witnesses. We don't have any materials. We don't know what the experts' precise opinions are and what they were testified to. And it's essentially, it is in bad faith and there's no less severe sanction. So the Commonwealth would move to exclude Dr. Russell. And at this point, we are essentially just seeking the reciprocal discovery that the Commonwealth is entitled to be able to effectively prepare cross-examination of these witnesses so late in the game. Thank you very much.
All right, who's arguing this for the defendant?
There's no mic at council table, so I'm going to go to the podium with the court's permission.
Yes.
We need to be heard on this.
That's why we're here, Mr. Yannetti.
Thank you. I'd like to start with the most outrageous and false assertion that the Commonwealth made in its motion.
Can I just ask you, there's no jury here, can I just ask you how long this is going to take?
Between 5 and 10 minutes.
Okay.
tops.
Because I don't need, the hyperbole.
Your Honor, I need to make my argument in the way that I think is most effective for my client. I will keep this brief and succinct, but I have points to make that I need to put on record.
Okay, and I'm the person you are trying to convince, correct?
I understand that. The Commonwealth, in a public filing, wrote the following on page 3 of its motion. Quote, during a pretrial hearing on February 15th, when asked by the court whether there was any dispute about a canine's involvement or canine DNA, Attorney Yannetti indicated no, and that the defense was not pursuing such claim. I was astounded to read that for 2 reasons. First of all, it is false. It is a lie. Second, the Commonwealth has knowingly lied about something where it's easily verifiable that they lied. We pulled the tape from February 15th.
I don't have that.
I'm sorry?
I don't have that in my motion.
It's on page 3, Your Honor.
I have the Commonwealth's renewed motion for reciprocal discovery, a motion to exclude defendant's expert, Dr. Marie Russell. I don't see your name at all, Mr. Yannetti. I'm on page 3.
I'm sorry, it's not page 3, it's page 4. My apologies. My name is right there on page 4. It says exactly what I just argued to the court. It's about the 5th line down. It starts during a final pretrial hearing on February 15th, exactly
Okay.
as I said.
Okay?
All right? We pulled the tape from that February 15th hearing. Here is what was actually said. This court asked me the following, quote, while we're talking about DNA, Mr. Yannetti, do we need to be concerned about canine DNA? Where do we stand with that? I replied, no, I think this is the only outstanding DNA issue. The court then replied, okay, so all right, we're not dealing with canine DNA. And I said, no. There is nothing in there, contrary to what the Commonwealth has represented to this court in a public filing, that I said there was no canine involvement. There is nothing in there, contrary to what the canine represented to this court and to the public, that the defense was not pursuing such a claim. Can you imagine the nerve of the Commonwealth to spend that interaction?
This is the hyperbole I don't need. Could you please get to the point? We've got a jury coming in 15 minutes.
I understand, but this is my integrity has been attacked. There have been allegations of bad faith that has been attacked, and I need to defend myself and my client. We were only discussing at that time whether canine DNA was still outstanding, and I succinctly replied, no. And they've spun that, or tried to spin that, into a claim that we're somehow waiving our right to argue that John O'Keefe's arm injuries were consistent with a dog attack. And I ask you, have they no shame?
And that's the point, Your Honour. Trying to exclude Dr. Russell on a false premise outlined in their motion. Here we see a perfect example of her not allowing them to put on the record what they need to put on the record for the purposes of appeal and, yes, even for the purpose of the habeas petition.
I'm sure it's not lost on this court that this false filing by the Commonwealth comes on the heels of their nefarious attempt to pass off an inverted video, a false video, before this good jury hearing this case. Never once during the direct examination of Sergeant Buchanan did they inquire or mention the fact that the video...
Can we please... All right, I'm going to stop you. please direct your comments to Rule 14 and the reciprocal discovery obligations that the defense has. That's what this motion is. I know you have a speech you want to make, Mr.
It's
Yannetti.
not a, Your Honor, it's, most respectfully, it's not a speech. It's
Okay,
it's a defense of being alleged to have committed bad faith.
So you've moved on from that. So please just focus on Rule 14, and let's do it in two separate parts. So you've changed, you're not calling Frank Sheridan,
No,
right?
we are calling Frank Sheridan.
All right, so you've got a new medical, Dr. Russell. We'll do that part of it separately. So is the Commonwealth satisfied that when did you provide anything recently since the filing of the Commonwealth's motion, Mr. Yannetti?
Not on Mr. Vanny, no.
What does the Commonwealth have on Mr. Vanny?
On Mr. Vanny, all the Commonwealth has is what's contained, the synopsis on page 2, the first full paragraph. We do not know what his opinions are. It says he'll testify regarding his opinions and conclusions about reconstruction and EDR data obtained in connection with this case. He'll testify to chronological data derived from the EDR, including key cycles and triggering events from the time period in question. I have no understanding or information about what chronological data he's going to testify to, what his ultimate opinions are, anything beyond that relatively vague synopsis that does not comply with Rule 14.
Okay.
Oh, so you don't know what data the Trooper Paul used to develop his accident reconstruction theory? Because that's the data that was given to the defence. I now understand a little bit better about why the defence didn't use this witness, because look at the struggle they've got just getting Dr. Russell and the two ARCCA witnesses, which ended up being the entirety of their witness lists. Almost. This next clip is quoted by Brennan in the last Tantrum trial, verbatim. He quotes this date as the 10th of June transcript.
Similarly, what's outlined in the rest of the motion, that's all the expert evidence the Commonwealth has received from the defense is contained within the Commonwealth's motion.
Okay. So the defense needs to provide, I'd suggest you listen, the defense needs to provide what chronological data Mr. Vanny relied upon and exactly what his opinion is. All right? By the close of business tomorrow.
That's fine.
All right? Now, regarding the three experts from ARCCA. So I've read that report. I can't tell who does what or what the basis of their opinion is. So what have you provided?
Your Honor, we've provided everything that we know. We've mentioned to this court at sidebar, these experts did not arise from us.
I understand that.
These experts were hired by the federal government, and they provided a report to us pursuant to the TUI request, and it was specifically outlined that and ruled that they could not prep with us for trial.
So I'm to believe that the defense is calling three witnesses that you've never spoken to and putting them on the stand here
That's essentially it. We've spoken to them only for the purposes of coordination of their testimony and their background. That's it. We have not been able to interview them regarding their findings, which are outlined in detail in the reports that both sides have.
See, I don't see that as being, the report, I don't see that as being detailed. It leaves a lot of questions as the gatekeeper as to what they can testify to.
Well,
and you have not complied with your Rule 14
We
obligations.
can't, Your Honor. We can't.
So you can't, but you haven't. So I am left with you haven't complied.
Hold up, Auntie Bev. Sanctions cannot be used as a punishment. Sanctions under Rule 14 must be tailored to prevent unfair advantage, not arbitrarily penalise one party. Under Commonwealth v Lapointe, 2001, the SJC held that Rule 14 sanctions must serve a remedial purpose, and that judicial overreach in imposing unnecessary sanctions can amount to abuse of discretion. So if the judge imposes a sanction, despite the fact that the defence can't produce what she wants them to produce, because it's not in their power to do so, it suggests that she's improperly siding with the prosecution rather than neutrally enforcing the rules. The FBI witnesses are outside the defence's control under the TUI regulations. The defence can't compel the FBI to provide additional Rule 14 discovery due to TUI regulations. Under United States, TUI versus Reagan, 1951, federal agencies have exclusive control over how and when their employees testify. The defence did not have the authority to force the FBI to disclose more than what was already provided. Punishing the defence for something outside its control violates due process. This is an abuse of discretion because it punishes the defence for a federal agency's policies rather than any actual defence misconduct. Under United States versus Nixon, 1974, the courts cannot sanction a party for discovery issues arising from a third-party government agency that has independent disclosure rules. If the defence should include this in the federal habeas petition, under Bracey versus Gramley, 1997, the habeas court can examine whether the judge's repeated rulings favoured the prosecution in a way that violated due process.
So, we need to get everybody here for voir dire. They can testify in a voir dire, right?
Yes.
We need to do that well in advance of their testimony.
Okay, that's fine, Your Honor.
All right?
Yep.
And now tell me about this ER doc. Is she an ER doc? I haven't seen her. She's not a pathologist, correct?
She's a pathologist, but she has a lot of experience in an ER, which is why she has the experience of having seen dog scratches and dog bites and dog attacks.
All right, so this is not somebody that was involved in the federal investigation, correct?
Correct.
All right, so you need to provide immediately. I want a voir dire of her this week. So we can get her here Wednesday, and we want the other folks up here from Pennsylvania this week as well.
Okay, we'll make those calls.
So we need to pick a day. How long do you expect the voir dire of each of these witnesses? If, in fact, the defense has not spoken to these witnesses from Pennsylvania about the nature of their opinion, you must want it too, to be able to question them. How long do you expect the voir dire of each of these witnesses to take? I went and told the jury last week,
I'm sorry, I was just,
last week that we were going to get them this case by the end of the month based on your representations, which included voir dires. It looks like at least a day of voir dire hearings here.
Yeah, except what you're going to see towards the end here is that based on the defence's representations, it did only take half a day, and they ended up with a whole bunch of time free because Judge Bev greatly exaggerated it.
at least with regard to the, of course, at least with regard to the ARCCA witnesses, that's my co-counsel's bailiwick. He anticipates that unless there are, a substantial number of objections during the voir dire, he anticipates being able to accomplish that between 45 minutes to an hour with each of those three. With regard to Dr. Russell, we anticipate a half hour. Oh, I'm sorry, there's only two from ARCCA, that's right.
You're only calling two? Which two? Are you calling the two that are certified as accident reconstructionists?
Doctors Rentschler and Wolf, yes.
I'm not entirely sure why the sound dropped out there. Maybe Judge Bev pressed the mute button, but it does seem that quite a lot of conversation went down in this period, including Lally standing up and doing his usual long-winded objections. It's important to note that Judge Bev decided, instead of sanctions, she would award the Commonwealth some kind of sanction, but in the way of voir dire. And as Jackson duly points out in the next section, it essentially benefits the Commonwealth because it gives them what amounts to pre-testimony deposition, or 2 bites at the apple, as Jackson says. So if this is a remedy for the Commonwealth, to give them 2 bites at the apple, then once the pre-testimony deposition is complete, the remedy is fulfilled and Judge Bev doesn't need to apply any more sanctions, right? Right?
Your Honor, before we get started, can I get an understanding? We started to say it at sidebar the other day, and you said you wanted to put that off to get to the witnesses. But I need a little bit of an understanding of what the court's expectations are. My understanding of voir dire, which this seems unusual in terms of the timing of it.
So the understanding of the voir dire is this is for the Commonwealth's motion to exclude this testimony. All right, that's what we're here for, the Rule 14 violation.
Is that the same with Dr. Wolf and Dr. Brinch?
Well, I thought that would help both of you. The Commonwealth has nothing on that, and you say you haven't been able to even talk to them at all about this case.
That's correct.
So I want to find out if they have any credible, competent evidence to put forward. So we'll have a voir dire on them as well. But for Dr. Russell, what we're doing here today is there's an alleged well, there appears to me to be a violation of the reciprocal discovery obligations of defense counsel regarding Dr. Russell. So let's hear from her today to see what the appropriate remedy is for this violation.
So my intention is to ask her so I have, the court understands my sort of guardrails. My intention is to ask her what her qualifications are, which is that's the basis for voir dire. And that's where I'm going to stop. I'm not intending to ask her what her opinions are, conclusions. I'm going to ask her if she's come to opinions and conclusions, but I don't want to have to examine her concerning her full opinions or full conclusions, what she's based those conclusions on. It's unfair. We've provided the defense the prosecution, everything that we need to provide to them in terms of disclosure. They've got the equivalent of a report. They've got a summary of what she's going to testify to.
When was that provided? My order was 1 week from the start of trial, right?
But we didn't, Your Honor, in fairness, they didn't even finish their discovery 1 week before the start of trial. So it's a little unfair for us to be put on the stand.
1 week from the filing of the certificate of compliance.
Well, I don't know when I can't remember. My co-counsel indication is the day before trial.
Okay.
So during the course of, look, trial is a dynamic thing. During the course of the trial, I did not know who Dr. Marie Russell was at the time that they filed their certificate of compliance. We then attempted to and did give them the reciprocal discovery that we were obligated to do after they filed their certificate of compliance.
When?
Within 3 days of that. We had been giving them information prior to that, but at least within 3 days of that. We've continued, so the record's clear, we've continued to get additional discovery from the Commonwealth in notices of discovery throughout the trial. They have not finished. In fact, during the trial, they interviewed Jen McCabe, apparently, had a full interview with her. Lieutenant Tully took a report, dated the report, and then they held on to that report until after she testified. The interview, the report, and the completion of the report were all done before her testimony.
Do you need to call her again?
Your Honor, that's not my, and I think the court understands, that's not my point. My point is not I need to call Jennifer McCabe back. I've done the damage that needs to be done on Jennifer McCabe. The point is...
I'm sorry, I missed that. You've what?
I've done the damage that needed to be done on Jennifer McCabe. I don't need to call her back. The point is that what's good for the goose is good for the gander. The Commonwealth doesn't get to stand in the position of piecemealing and feeding us information, reports, discovery throughout the course of the trial. And by the way, when we then got seminal information about an expert that we did not know about, never met, never heard of, within 3 days of that, we provide everything that we have about that witness to the Commonwealth. They can't then turn around and say, oh, well, it's all the defense's fault. So we want to have a voir dire, which means that the euphemism for that voir dire is we want to have two bites at the apple.
Okay.
We want to be able to completely cross-examine her, then go back to our expert, and if she testifies, cross-examine her again after consulting with our expert. That's 2 bites at the apple, and that's not fair. If the court wants to hear whether or not Dr. Marie Russell is qualified to testify about the arm injuries, that, I believe, is the parameters, the proper parameters of the voir dire, and that's what I'm prepared to do today. But I wasn't planning on getting into the substance of her testimony because that's been provided. And I don't think Mr. Lally should be able to get into the substance of her testimony because he knows what the substance is because, like I said, that's been provided.
All right, so I disagree. I'm going to hear from the Commonwealth on this.
Ugh, of course you do. Here's the thing, Arnie Bev. Case law agrees with Mr. Jackson. In criminal proceedings, the principle of equal application of discovery rules is fundamental to ensuring a fair trial. Massachusetts Rule of Criminal Procedure 14 outlines these discovery obligations, mandating that the prosecution disclose all relevant material to the defence. The disparity that Jackson raises here raises concerns about the equal enforcement of discovery rules. The Massachusetts Supreme Judicial Court has addressed issues of late disclosure by the prosecution. In Commonwealth v. Light, the court considered whether the prosecutorial misconduct in a late disclosure of evidence constituted irremediable harm to the defendant, potentially precluding a fair trial. While each case depends on its specific facts, the court emphasised the importance of timely disclosure to uphold the defendant's rights. Furthermore, in Commonwealth v. Chikeri, it reiterated that the prosecution's obligation to disclose exculpatory evidence is not negated by omissions from the defence counsel. This underscores the prosecution's independent duty to ensure that all favourable evidence is shared with the defence, irrespective of the defence's actions. In summary, Massachusetts case law supports the principle that discovery rules must be applied equally to both parties. The defence's timely disclosure of a late witness contrasts sharply with the prosecution's continued late disclosures and introduction of undisclosed, potentially manipulated evidence. This imbalance could form the basis for legal challenges, including claims of prosecutorial misconduct and violations of the defendant's right to a fair trial.
So I do find that there is a violation of the reciprocal discovery obligations of Rule 14. And I'm quoting from the notes the importance of this, the reporter's notes to the old rule, and as you all know, we're in the process of updating that rule, but the very integrity of the judicial system and public confidence in the system depend on full disclosure of all the facts within the framework of the rules of evidence. To ensure that justice is done, it is imperative to the function of courts that compulsory process be available for the production of evidence needed either by the prosecution or the defense. So, what we're here to do today is decide a remedy for this violation. And that's why we're having a voir dire. I am not prohibiting the Commonwealth from anything on their examination of witness Mr. Jackson. The alternative is she doesn't testify. So the Commonwealth has not received the appropriate discovery from this witness. So we're going to have a voir dire, and they can ask her anything that they think they need to ask her. So those are the parameters of this morning.
As long as I know the guardrails, that's fine.
It's important to note that the prosecution carries the burden of proving the defendant's guilt and therefore has the broader disclosure responsibilities, especially concerning exculpatory evidence. The defence's obligations are typically more limited and focused on evidence it intends to present at trial. In Commonwealth v. Edwards, the Massachusetts Supreme Court emphasised that sanctions serve as a mechanism to uphold fairness in the trial process. Judge Cannoni's invocation of the old rule does not properly apply in this situation because Rule 14 sanctions should apply only if the defence willfully withheld evidence or caused prejudice to the prosecution. Massachusetts Rule of Criminal Procedure 14 does not punish good faith disclosures. If the defence only became aware of the witness 3 days prior and immediately provided full discovery to the prosecution, then no discovery violation occurred. Under Commonwealth v. Baldwin, 1982, the Massachusetts Supreme Judicial Court ruled that late discovery disclosures could only be sanctioned if they resulted in unfair surprise or prejudice. If the defence acted in good faith and disclosed information as soon as reasonably possible, sanctions are inappropriate. As AJ rightly pointed out, the defence did not violate Rule 14 because it did not withhold information. It disclosed the witness immediately upon learning about them. The old rule that Judge Bev invokes was designed for willful discovery violations, not unavoidable late disclosures. Historically, the old rule on discovery sanctions focused on preventing strategic withholding of information, not punishing unavoidable late disclosures. Under Commonwealth v. Durning, 1990, sanctions for late disclosures should only be imposed if the prosecution suffered actual prejudice and could not fairly respond to the evidence. Furthermore, if the judge penalised the defence for late disclosed witness while allowing the prosecution to introduce evidence without similar sanctions, this violates the equal application of law. Under Wardius v. Oregon, 1973, the US Supreme Court ruled that discovery rules must apply equally to both the prosecution and the defence. If Judge Canoni selectively enforced discovery rules favouring the prosecution, this strengthens the argument for judicial bias in the habeas petition. Rule 14 sanctions must be proportional and aimed at correcting prejudice, not used as a punishment for unavoidable situation. If the prosecution was given the opportunity to cross-examine the witness, then any potential prejudice was fully mitigated. Judge Canoni had no valid reason to impose sanctions if the defence promptly disclosed the witness as soon as it learned of them. This falls under case law, the Commonwealth v. Atkinson, 2004.
All right. Next witness, please.
With regard to Dr. Wolf and Dr. Rentschler, this is a different scenario, and I'm presuming that the court is asking for a year on their qualifications.
Well, I want to know who did what. I want to know, they say we. I want to know who did what.
So is the court suggesting that I go through their entire testimony of exactly what they did, their testing, their opinions, conclusions, the bases of their opinions, conclusions?
However you want to do it, Mr. Jackson, we're here today on the Commonwealth's motion.
I realize that, but it's not the Commonwealth's motion to depose our experts. The Commonwealth's motion is they're not qualified as accident reconstructionists. I don't need to go, and I'm not inclined to give them a free bite at the apple to cross-examine these witnesses twice on the basis of their opinion. I will go through, I think, to the court's satisfaction. I don't think it's going to take long to figure out that they're extraordinarily qualified to render opinions, but I don't think it's incumbent upon me to walk through their entire testimony and give the Commonwealth a free bite at the apple like it's a deposition.
Whatever you want to do. I'm not telling you what to do. Whatever you want to do.
So we're going to be able to give the court the case down here and should truth, the whole truth, and nothing but the truth, so help you God.
Yes.
Thank you.
Just very loudly into the microphone.
Whenever you're ready, Mr. Jackson.
Thank you, Your Honor. Sir, could you please state your name and spell your last name for the record?
Daniel Wolf, last name spelled W-O-L-F-E.
Sir, what do you do for a living?
I am the Director of Accident Reconstruction at a company known as ARCCA, A-R-C-C-A.
And tell us a little bit about ARCCA. If you could explain to the court what ARCCA is and what its primary mission is.
So ARCCA is a forensic consulting engineering company. We have a variety of disciplines that include biomechanics, failure analysis, human factors, premise liability, crashworthiness, and accident reconstruction.
Did you get that, Arnie Bev? He's the director of the Accident Reconstruction Division at ARCCA. I'll spare you guys the entire testimony, but basically he says his qualifications and he was given some information and told to draw some conclusions from it. Yet somehow Bev still doesn't get what it is that he done.
You're accredited by all of those organizations, is that right?
I'm a member of all of those, yes, sir.
Have you authored peer-reviewed articles in the area that we've just discussed?
I've authored a number of papers in the field of physics, and one of my most recent publications was that dealing with Toyota and Lexus vehicle control history records.
In 2021, did you author or co-author a peer-reviewed article known as Collision, the International Compendium for Crash Research Dealing with Vehicle Control History and Braking Issues?
Yes, sir.
Have you qualified in other courts to testify as an expert in the area of accident reconstruction?
Yes, sir.
Importantly, were you hired by the defense in this case?
No, sir.
Before this morning, when you walked into court, have you and I ever met face-to-face?
No, sir.
In terms of the commission that you were asked to undertake in this case, that have anything to do with the defense?
No, sir.
That have anything to do with the Commonwealth?
No, sir.
So a third-party agency hired you and commissioned you, or ARCCA, with the responsibility of doing an accident reconstruction in this case, correct?
Correct.
The person to my left, the female to my left sitting here, you ever seen her before?
Nope.
Do you know who she is?
Yes.
How many times have you been qualified in other courts to testify as an expert in the area of accident reconstruction?
I think that's around 20 times to date.
In both federal and state court?
Just state court.
Multiple states?
Yes, sir.
Your analysis, conclusions, and opinions are completely independent, whatever they are. Those analysis, conclusions, and opinions in this case are completely independent of the defense and of the Commonwealth. Have I got that right?
It's based on the evidence. That's correct.
And you're not paid by either side here in this courtroom?
Correct.
Aha! That's Mr. Breenan's supposed gotcha moment. So let's just refresh our memories what Mr. Breenan claimed about this gotcha moment.
So there is email correspondence between the defense, not only the federal government, but the ARCCA witnesses themselves. A recent request for their appearance pursuant to TUI, which I have no issue with. But if we look back earlier in the relationship, what we see back in March 22nd, 2024, is that there are conversations between the defense, Attorney Jackson, and Daniel Wolf, who's one of these ARCCA witnesses. Thank you so much for taking the time to get on the phone with me this morning pursuant to our conversation. Please feel free to forward an engagement letter to this email address. I will get that countersigned and return to you forthwith, along with your retainer as required. The Commonwealth, as I understand it, was not aware of any promised rewards or inducements or payment. They relied on a reciprocal discovery order of this court for that information. Response: Hi, Alan. Subsequent to our conversation on Wednesday, the U.S. Attorney's Office asked we pause any further conversation until we received additional information from their office regarding how our involvement will move forward. Now, it's not the opinion that troubles me, it's the relationship, and the Commonwealth should have an even playing field. Saturday, June 22nd, Daniel Wolf writes, Alan, I spent some time this morning putting together a brief outline of my qualifications. I'll also attach my D&T list. I obviously won't say what the response is verbatim, but I gave you a general sense of what my response would be. Again, I thought your questioning during the voir dire was fantastic, so please feel free to make whatever changes you feel necessary. Now, this isn't information provided by the defense in reciprocal discovery. This is information provided by the federal government after numerous requests, TUI requests, and an insistent, the best I can, to get as much information as I can. We then are provided an outline of questions and answers for a direct examination. The Commonwealth did not have the luxury to privilege, did not even know that there was an outline that was being disseminated by this totally independent witness who took no side other than that of the truth. What follows from this outline is then the outline with remarks from this independent expert who knows nobody. So we see in the margins in the notes, this fair-minded, objective witness says, so not being able to inspect the vehicle is something that's not uncommon in your line of work, and he writes, absolutely not, and then he comments, not sure if you want to put this somewhere in the direct examination. I have a feeling they, the Commonwealth, are going to argue I didn't personally inspect the vehicle. I had enough information from the material I reviewed, so it wasn't necessary. Need to show the jury it doesn't matter in this case.
What's the date of that?
It's not dated. It's not dated. The TUI request is a recent February response, but they send random documents. There's no real accounting.
I'm sorry, Mr. Breenan. What was that date again? Oh, you don't know. So how the heck do you know it's a gotcha moment? We've already talked about Auntie Bev's reaction to this and how that could be perceived by the federal courts as retaliation. And everything that she's ruled on up to this point either reeks of judicial bias or prosecutorial misconduct. I think we've already arrived at having raised serious questions about impartiality. But if she was assisting the state in undermining the FBI's credibility, this is going to be a big thing for the federal review in the habeas petition. And if you weren't convinced that Auntie Bev was seriously trying to undermine the FBI expert rather than making legitimate inquiries into his qualifications, listen to a line of questioning when Dr. Wolf wraps up.
And again, that was based on the evidence or whatever he was providing, correct?
Correct.
Which would be the same materials that you had testified that you had reviewed, correct?
Correct.
I have nothing.
Anything further, Mr. Jackson? All right, so, Doctor, I just have one question for you. What specifically were you asked to do?
I'm sorry, Your Honor, I didn't hear the court.
What specifically were you asked to do?
So the agency that retained us gave us a selected quantity of file material related to this case, and essentially left it as an open-ended question. Ultimately, was the evidence consistent with a pedestrian interaction between Mr. John O'Keefe and the Lexus?
Okay, you said selected quantity of information. Who selected that information?
Tell me, Auntie Bev, how is that relevant to his qualifications? You allowed this voir dire specifically to punish the defence for violating their discovery obligations, which under case law is completely void of legal propriety, for the purpose of, wait, let's use your own words?
The report, I don't see that as being detailed. It leaves a lot of questions as the gatekeeper as to what they can testify to.
Yeah, so you can decide what they're qualified to testify to. Not what information the FBI has, or what information the FBI provided its own experts. That's beyond the scope of this voir dire. And so it does look like you're assisting the state in undermining the FBI's credibility. Unfreaking believable.
As far as I'm concerned, it would be the Department of Justice and the FBI.
All right, and they just gave you what they wanted to give you as far as you know?
We had no say in what material was handed over to us.
Okay. All right. Thank you very much. Any questions based on my questions?
No, Your Honor.
Mr. Lally?
Just briefly. And I apologize for this. I'm just unaware. Is it Mr. Wolf or Dr. Wolf?
Dr. Wolf is fine.
So, Dr. Wolf, when you say that you were asked specifically whether or not the evidence, the limited scope that you were provided was consistent with a pedestrian collision, were you asked sort of in general terms as far as any type of pedestrian collision, or were you asked specifically as far as biomechanically could say the injury to the back of Mr. O'Keefe's head have been caused by contact with the vehicle? How open-ended was this question?
Again, I think it relates to, is the vehicle damage consistent with the pedestrian impact, and are the injuries consistent with the pedestrian impact?
And again, the whole panoply of injuries, is that correct?
I'm sorry, what was your question?
Let me rephrase. So did anybody specifically ask you to determine whether or not the injuries to the back of Mr. O'Keefe's head could have been caused by a motor vehicle?
I don't know that they asked us specifically. Again, they basically asked us to perform an accident reconstruction and biomechanical analysis and basically tell them our findings, and these are our findings.
And in the materials that you reviewed, did you see anything in there of any sort of statement, suggestion, intimation, anything at all that suggested that the injuries or the fracture to the back of Mr. O'Keefe's head was caused by a motor vehicle?
In terms of direct contact?
Yes.
No, I don't believe so.
Nothing further.
Anything?
Nothing.
All right, Dr. Wolf, you are all set, sir.
Thank you.
Note, neither the prosecution nor the judge asked any questions, about his qualifications to testify in relation to any matter that was raised in the motion. As Jackson said, it was simply a pre-testimony deposition brought about by a false premise in the motion. We'll come back to this in a minute.
Have you ever testified in criminal court as an expert in biomechanical engineering?
I have, yes.
How recently have you testified in criminal court?
Well, actually, I've testified twice. The end of May, I think May 31st, I testified in McKean County, Pennsylvania. For the prosecution, it was a case where the defendant was accused of beating his girlfriend to death and basically said that she fell down the steps. So my testimony involved determining how her injuries occurred and that they were entirely inconsistent with what would have happened during a stair fall.
What about another case?
And then about a week after that, around June 6th or 7th, I testified in Cambria County, Pennsylvania, again for the prosecution for another homicide case where the defendant was accused of essentially beating his wife to death and then said that she actually fell backwards and struck her head, caused a skull fracture on the side of the sink. So my testimony, again, pertained to looking at the injury mechanisms and determining that his story of her falling back and striking her head on the sink, it's inconsistent with the injuries and the type of force that would have been exerted in that case.
In both of those murder cases, you were hired or retained by the prosecution in the case, not by the defense, correct?
That's correct, yes, sir.
You gave your opinions in furtherance of the prosecution's case in chief, not the defense case in chief, correct?
That's correct, yes.
Another point to note. Dr. Rentschler, not Mr., has previously given this same type of expert testimony regarding injury causation. So if this testimony has been permitted in previous cases in the past, excluding it for the defence raises serious concerns about fairness and judicial bias. Massachusetts law does not automatically prohibit biomechanical engineers from testifying on injury causation as long as they meet the Daubert-Lanigan reliability standard. So again, what is it that we expect the questions to sound like? Whether expert testimony is admissible based on its scientific reliability. Daubert v. Merrill Dow Pharmaceuticals, 1993, established that expert testimony must be based on scientifically valid principles. Commonwealth v. Lanigan, 1994, adopted Daubert in Massachusetts, requiring that expert testimony be based on reliable methods and principles, not just prior acceptance. Massachusetts courts have permitted biomechanical engineers to testify how injuries occur as long as their conclusions are based on reliable science. Commonwealth v. Fritzsky, 2016, allowed an expert in biomechanics to testify about the mechanics of how an injury occurred but required scientific validation of the methodology. Mr. Breenan's favourite word. So, was the Commonwealth or the judge interested in any of these things? Let's see.
With regard to this case, you were asked to look at several items. We've already gone over those in the other testimony, so I won't belabor that. You were asked to look at several items, correct?
I was, yes.
And ultimately, based on that series of information, that universe of information that you were provided, see if you could come to an opinion and conclusion concerning the incident before the court now, correct?
That's right. See if I could determine what happened, how the injuries occurred, and the events leading up to and during that process.
Without going into your conclusions and opinions, were you able to come to conclusions and opinions to a reasonable degree of science and concern?
I was, yes, sir.
You were not hired by the defense, by me, or anybody on the defense side in this case, correct?
That's correct. I was not.
You were not consulted with or hired by the Commonwealth either?
That's correct. I was not.
It was a completely independent agency, is that right?
That is correct, yes, sir.
Before this morning, have you and I ever met?
No, sir.
And you and I have never talked about the substance of your opinion and conclusion, correct?
We have not. That's correct.
You did reduce those opinions and conclusions in conjunction with your team to a report, is that right?
I did, yes, sir.
And your understanding is that report was made available both to the defense and the Commonwealth in this case, is that right?
Yes, sir. That's correct.
I have nothing further to add.
Okay, Mr. Lally?
Thank you, Your Honor. sort of close the loop on this. When it comes to those 14 items, were you allowed to ask for any additional items, or was it just you were limited to this is what you have, go form an opinion?
There may have been discussion about if there's other information available, but I believe ultimately that we rendered our opinions obviously just on this specific information that was provided to us.
Now, as far as your opinion in your report, when was that issued?
February 12th of 2024.
So that date on the top of the report of February 12th, 2024, that's when you sent the report to the people that contracted you to do the analysis in the first place?
That's correct, yes, sir.
So the report was produced long before the defence knew the report was produced, and the Commonwealth for that matter, which was also long before the defence made their first contact with these two experts. So how is it that paying for their expenses a few months later influenced the report that they wrote in February, Mr. Breenan?
And what I'm trying to ascertain here, Doctor, is just sort of the different roles that you and the other members of your team performed in reference to this. Am I correct in that your primary role in this pertained to the sort of biomechanical engineering analysis of injuries sustained by Mr. O'Keefe?
That would be correct, yes, sir.
And not to put too fine a point on it, but Dr. Wolf would have been more responsible for issues related to the vehicle itself.
Generally speaking, yes, that would be correct.
Obviously, there's some interaction between damage to the vehicle and injuries to Mr. O'Keefe, but as far as your primary sort of any opinions contained within this report pertaining to injuries to Mr. O'Keefe, those would be your opinions, correct?
Yes, any opinions or information with respect to the injuries would be my purview and my opinions in this matter, yes, sir.
And concomitantly, so any opinions related to damage to the motor vehicle, those would be opinions of Dr. Wolf, is that right?
Well, to some extent. I mean, certainly I would have opinions as well based on the interaction or alleged interaction between the body and, for instance, the vehicle in this case, and what damage to both the body as well as the vehicle you would expect. So I think there's basically some overlap between those issues. I wouldn't say that it's a complete separation.
And so, and again, Doctor, what your opinions or ultimate conclusions are, whether they be yours or Dr. Wolf's or a combination of the two, it's all limited based on the information and the evidence that you received, correct?
It certainly is based on the information that we reviewed and listed in our report. Yes, sir.
Now, as far as for the mandate or from the agency that hired you, were you asked to answer a specific question, or were you asked to just do an analysis based on what we sent you, or how was that put to you as far as what you were doing?
There was a specific request that we were asked to perform and to evaluate in this case.
And specifically what I'm asking, sir, is there's an analysis in there of whether or not the injuries to the back of Mr. O'Keefe's head could have been caused from contact with the vehicle, correct?
That is part of my analysis and opinions, yes, sir.
And were you specifically asked to address or answer that question by the agency that hired you?
That was one of the questions I was specifically asked, yes, sir.
I have nothing further.
Anything further, Mr. Jackson?
Thank you.
All right, so, Doctor, I have a couple of questions for you, sir. So regarding this specific request, what were you tasked to do specifically?
So specifically overall, I was tasked from the biomechanical standpoint to determine or see if it's possible to determine how the injuries in this case occurred. And part of that was determine whether the injuries, the head injury and the arm injuries resulted from contact with the Lexus in this case.
Again, both the prosecution and the judge are asking cross-examination questions. These are not appropriate for the purpose of voir direing an expert for their qualifications. This is simply mining for information to undermine the FBI's testimony.
Okay. And regarding all of your prior testimony, a good deal of it seems to be in depositions. Any of those in Massachusetts?
There's a couple, I believe. I've testified at trial in Massachusetts,
Okay.
Middlesex Superior Court.
Do you know where that might be? I do want to look at that.
I can find it for you, maybe a couple of months ago.
Was it in a criminal case or a civil case?
Oh, it was in civil case.
Okay.
I think, let's see here. Yeah. So let's see. There was one November 14th, 15th, 2023, Middlesex Superior Court. That was probably the most recent one.
Hey, what number is that on there if I want to go back and look at it?
That is number 310.
Thank you. Is there another Massachusetts case?
Oh, I'm sure there are, because I know there's some from earlier in my career. Let me see.
Objection. Relevance. There's several possible reasons, none of which are legally justified or particularly relevant, as to why Judge Cannoni would ask about prior testimony in Massachusetts. It could come back to an attempt to cast doubt on the witness's qualifications or relevance, like if the judge was looking for a reason to diminish the FBI's expert's credibility. She may have been trying to suggest that his testimony was somehow less valid because he had not previously testified in Massachusetts courts. However, this is legally irrelevant. An expert's credibility is based on their expertise, methodology, and experience in the field, not whether they have previously testified in a specific state. She may have also been trying to create grounds for exclusion or restricting the scope of testimony, a pretext, if you prefer, to limit, exclude, or devaluate the FBI expert's testimony. If she could establish that the witness had no Massachusetts-specific trial experience, she might attempt to argue that his testimony should be given less weight. Why this argument fails? There's no legal requirement that an expert must have prior testimony experience in a particular jurisdiction to be deemed qualified. Federal courts and other state courts routinely allow experts based on their subject matter expertise, not location-specific testimony history. Obviously, the relevant case law is Daubert and Lanigan. One other consideration might be political or institutional pressure against the FBI's involvement. Given that federal investigators were already involved in investigating potential misconduct by state law enforcement, Judge Cannoni may have been politically motivated to question their credibility. If the FBI's expert testimony was going to contradict the state's accident reconstruction, the judge may have sought to discredit him in an attempt to protect the prosecution's case. This would be improper because judges are supposed to ensure a fair trial, not assist the prosecution in undermining opposing expert testimony. If the judge was singling out the FBI witness or witnesses for undue scrutiny, this could be grounds for judicial misconduct concerns. The relevant case law would be Bracey v. Gramley, 1997. If a judge demonstrates bias against a party or a witness, it may violate due process. Does it matter if the FBI expert has testified more than 300 times nationally? No, it doesn't matter whether he has testified no matter how many times, or even in Massachusetts specifically. Expert testimony is judged on reliability, methodology, and expertise, not geography. If he has testified in criminal trials for the prosecution in other jurisdictions, it demonstrates that his qualifications were accepted by multiple courts. Excluding or discrediting his testimony based on lack of Massachusetts-specific experience would be an abuse of discretion. The legal standard for expert testimony falls under the Federal Rules of Evidence 702 and the Massachusetts Guide to Evidence 702, and experts' qualifications do not depend on whether they have testified in a specific state before. And the United States v. Brown in the 11th Circuit Court of 2005, an expert's credibility is assessed based on their knowledge and methodology, not their courtroom experience. In the broader context, it appears that Judge Cannoni is trying to control the narrative. Her questioning may be evidence of judicial bias if the federal court determines that the judge sought to discredit a witness solely to protect the state's case.
All right. right, so, Mr. Lally, I will hear you on your motion. Now, we didn't get into the ultimate opinions and the basis for that opinion, but I'll hear you on your motion.
Your Honor, what essentially what Commonwealth was seeking and had been seeking was just in reference to that, as far as who did what and who was responsible for what and what were the items reviewed, and is that the totality of it? There's a date on the report. I don't know if that was a date as far as when it was filed, when it was opinion was rendered, when that was provided, what was provided to them in the course of their analysis. So I think very simply what the Commonwealth had been seeking for the most part was covered today.
Okay. All right, I have some questions as to the scope of the testimony of the witnesses. So, Mr. Jackson, you intend to have them testify consistently with the report, everything covered in the report?
Correct.
And the conclusions, all 4 conclusions in the report?
Correct.
All right, Mr. Lally, what's your take on this?
I do have an issue with number 4. I don't think they're qualified to testify to. I don't think either of them is qualified to testify to that. That's more of an area of forensic pathology.
Dude, you didn't even ask them about their qualifications. You can't now turn around after being given full opportunity to ask them about the qualifications to claim that they're not qualified. And as we just established from the case law, they're more than qualified.
What do you say to that, Mr. Jackson?
Number 4 is, their opinion is, there is currently insufficient evidence to determine the cause of Mr. O'Keefe's skull or brain injuries or the circumstances surrounding the event. That is well within the scope of their expertise. Obviously, I don't think I have to beat this dead horse. They are highly, highly qualified to render all 4 opinions. And if the evidence in their opinion, their expert opinion, to a reasonable degree of scientific certainty, which is what's evidenced here by the report, is that there is insufficient evidence to determine the cause of Mr. O'Keefe's injuries, then that is an opinion that they are well within it's well within the scope of what they can testify to. That's their opinion, that's their conclusion. Mr. Lally is going to have an expert, Trooper Paul, who's going to differ, or who has differed in that opinion. So be it.
And I would have kept it out. Remember, I would have kept out any medical part had there been an objection. And when you objected, I sustained the objection.
I think we're talking about 2 different things, apples and oranges. That's not, Trooper Paul's opinion is that his injury or his injuries, or I think he said variously that it was blunt force, could have come from the curb, or it was blunt force because the road was blunt. That was his opinion, and he was sticking to it. This is contrary to that. Both of these individuals have come to the conclusion and opinion that the evidence is insufficient to support that determination, and it's well within their purview to testify to that.
Your Honor, if I may, I don't think that's their actual opinion. I initially didn't think of it in these terms as it's phrased on the cover page of the report. If you look at the actual opinion
I
and
was
findings,
looking at the last page. Are they the same on the front and the back?
I think the front is a little more definitive and concerning. The back, I think, more as to it's consistent with a whole multitude of different things. So the fact that I don't really think that's an opinion at all, to be honest with you.
All right, I'll take a look at this more closely, give you a decision Thursday. All right, I did not expect it to go this quickly. We could have had the jury here, but...
Yep, that's on you, Bev. The defense told you the time frame and you argued with them. Anyway, the 3 voir dires, Dr. Russell, Dr. Wolf and Dr. Rentschler, were the remedy to the defence's supposed violation of discovery obligations. So essentially, the state obtained what it requested in the sanctions motion, which amounts to pre-testimony deposition. This was the remedy. It should have resolved the issue without further sanctions. Right?
The second part of the Commonwealth's motion Commonwealth argued that they were not provided reciprocal discovery regarding the biomechanical engineers and others, but specifically ARCCA, Dr. Wolf, and Dr. Rentschler. And I do find, though I understand why the defense didn't respond, but it is a violation of Rule 14, so we had this voir dire. The Commonwealth was looking to see what each person did, their independent opinion, what their testimony would be, and whether they were qualified to render the opinions that they qualified. So from what I heard the other day, Dr. Wolf can testify to what his involvement. Dr. Rentschler, though, I have some concerns. It's clear to me that in Massachusetts, biomechanical engineers are not qualified to testify as to medical causation of an injury. Only an MD can do that. So I'm going to reserve ruling on the rest of his testimony. There are certain things he can testify, and I'll hear you again before he testifies next week. Let's just proceed with the trial today. So,
Yes, Your Honor.
okay, so those are my rulings. Are they clear, Mr. Jackson?
Yes,
Are they clear, Mr. Lally?
Yes, Your Honor.
Okay.
Well, they might be clear, but they're not legally proper because she's now double sanctioning them. It was improper for Judge Cannoni to impose sanction on the defence under the Massachusetts Rule of Criminal Procedure 14 after already granting the state's requested relief. By sanctioning the defence anyway, Judge Cannoni's ruling appears punitive rather than corrective, which raises serious due process concerns. Again, the purpose of Rule 14 sanctions is to remedy a discovery violation, not to punish the defence if no actual prejudice has occurred. A sanction is improper if the state has already been provided the remedy it requested. Under case law, Commonwealth v. Durham, 2006, the Massachusetts Supreme Judicial Court ruled that Rule 14 sanctions must be proportional and necessary to address actual prejudice. If the prosecution obtains the requested remedy without undue harm, sanctions are not warranted. Obtaining the voir dire and pre-testimony deposition fully addressed any discovery concerns the state had. By issuing sanctions on top of that, the judge went beyond what was necessary to correct the issue, making the sanctions punitive rather than remedial. A court may not impose sanctions as punishment or retaliation, especially against the defence in a way that benefits the state. Rule 14 sanctions must be tailored to prevent unfair advantage, not arbitrarily penalise one party. We already stated the case law for that, Commonwealth v. LaPonte, 2001. If the judge imposed sanctions despite the fact that the state already got what it requested, it suggests that she was improperly siding with the prosecution rather than neutrally enforcing the rules. And as already mentioned, another major flaw in the judge's ruling is that the defence could not compel the FBI to provide additional Rule 14 discovery due to two irregularities. The judge sanctioned the defence despite knowing it was legally unable to force the FBI to comply further. This is an abuse of discretion because it punishes the defence for a federal agency's policies rather than any actual defence misconduct. Again, United States v. Nixon, 1974. The judicial overreach and the judicial bias can be examined by the habeas court as to whether the judge's repeated rulings favoured the prosecution in a way that violated due process. Now look, I can understand if Judge Beverly Cannoni can explain away not polling the jury as an isolated event. I can even understand the SJC writing it off as an isolated event. But we are now 5 videos in with a major list of cumulative issues that range from judicial bias all the way through to judicial misconduct. That's not even counting the police misconduct and the prosecutorial misconduct. So to close out, I know that many of you are going to be asking me which do I think is the most egregious misconduct by Judge Bev, and I would measure it by the hugest consequence according to case law. The one that comes to mind is putting Trooper Fenning in charge of the jury and their notebooks. But let's face it, if Marty Weinberg's got his thinking cap on, he's gonna accumulate all of this just the same way that I did. There's absolutely no way Judge Bever's explaining away this mountain of due process violations, judicial bias, judicial overreach, judicial misconduct. I'd bury that biatch. But like I said previously, it's got to be a strategic decision, what you're going to do and how much you're going to do of it, lest you end up with the same judge at the other end anyway. And if Karen doesn't want to bury her the way I want to bury her, then she's a way better person than me.